Welcome to our video series Data Act Unlocked. In this series, we provide a concise overview of the most important provisions of the EU Data Act. In this episode, we will take a look at dispute settlement. This is of central importance for the effectiveness of the rights and obligations established in the EU Data Act. After all, their value depends on whether they can be enforced in the event of a dispute. The EU Data Act introduces various enforcement mechanisms. First, by way of public enforcement, affected parties have the right to lodge an effective complaint with the competent authorities of the member states. These authorities are responsible for ensuring compliance with the EU Data Act and have the power to take supervisory measures in the event of a violation. In addition, however, the parties involved can also enforce their rights directly against each other, which is referred to as private enforcement. In this case, legal recourse to state courts is available. However, this is often lengthy and expensive, which makes it considerably more difficult for private individuals and small and medium-sized companies to enforce their rights. For this reason, in Article 10 of the EU Data Act, the European legislator provides an alternative dispute settlement procedure through specialized dispute settlement bodies for certain disputes in addition to state jurisdiction. The dispute settlement procedure applies to users, data holders, or data recipients in relation to contractual restrictions for the reasons of safety, health protection, and protection of trade secrets. It also applies to data sharing with data recipients on so-called FRAND conditions. Furthermore, this form of dispute settlement applies to cloud service providers and their customers in relation to violations of the rights of customers and the obligations of cloud service providers. Comparable dispute settlement mechanisms can also be found in other legal acts designed to make the EU fit for the digital age, such as the Digital Services Act. These provisions are based on the Directive on Alternative Dispute Resolution for consumer disputes. The aim is to help the parties settle disputes in a simple, fast, and cost-effective manner. The dispute settlement body shall be easily accessible through electronic communication technology, conduct procedures in an official language of the European Union, and reach a decision on the dispute within 90 days. The parties must also be informed in advance of the costs involved. Recourse to a dispute settlement body is only possible if no other dispute settlement body or court is already dealing with the same matter. In order to ensure the independence, impartiality, efficiency, and professional qualifications of the dispute settlement bodies, they must be certified in advance by the member states. With regard to the procedure before the respective dispute settlement bodies, the EU Data Act only makes rudimentary statements about its specific form, but makes it clear that it must comply with the principles of the rule of law. The parties must be given sufficient opportunity to express their points of view during the proceedings. The final decision shall be made in writing or on a durable medium and shall include a statement of reasons. Unlike a court decision, however, the decision of such a dispute settlement body will only be binding if the parties have explicitly consented to its binding nature prior to the proceedings. In the interests of efficiency, no legal remedy is provided for, unlike in court proceedings. Currently, a number of procedural issues remain unresolved. It is therefore possible that the EU legislator will provide dispute settlement bodies with guidelines, for example, in the form of model rules of procedure. On the other hand, the leeway also allows for competition and innovation between dispute settlement bodies, which may ultimately benefit market participants. To wrap up, here are the key takeaways from this episode of our new series, Data Act Unlocked. In addition to the possibility of enforcement by public authorities and courts, the EU Data Act offers special dispute settlement bodies. These are intended to provide a simple, fast, and cost-effective solution. At the same time, however, procedural principles under the rule of law must be observed, and the binding nature of such a decision must also be explicitly agreed upon. In practice, it remains to be seen to what extent the parties involved will make use of this dispute settlement instrument. We're glad to have you following our series Data Act Unlocked. For more insights, check out #CMS Data Law or visit our website.